me. So, hi everyone. I am Deanna Kelly Saeed. I work for the North Carolina Writers Network, and I represent PEN America here in North Carolina Piedmont. Thank you so much for being here tonight. We look forward to an intimate and hopefully powerful conversation. I do have some notes I need to read to you. I'm sure all of you know this, but in case you don't, the United States incarcerates more people per capita than any country in the world. Our Carceral Country series brings together authors, journalists, and activists from a variety of disciplines to discuss policing and incarceration in North Carolina and across the country. We want to reconsider how we might shift the way we approach policing, the criminal justice system, and incarceration by bringing together not only experts, but those who have worked in these systems as well as those victimized by them. Our next Carceral Country event is tomorrow at 6 p.m. Rebecca Todd Peters from Elon University and Jennifer Maffatore, I believe is her name, from the NC-ACLU will discuss reproductive justice, religion, and the law. On November 11th, I will be in conversation with journalist Phoebe Zurich about innocence and conviction. I want to introduce our speakers, and I'm going to slide off camera now. Carissa Byrne Hessick, is that your name?
That's right.
Serves as the Anne Shea Ranzel and William Garland Buck Ranzel Jr. Distinguished Professor of Law and as the Director of the Prosecutors and Politics Project. Her work has appeared in the California Law Review, the Cornell Law Review, the LA Times, the UCLA Law Review, and the Virginia Law Review, among others. She founded the Prosecutors and Politics Project in 2018, and she currently serves as a reporter for the ABA Criminal Justice Section Sentencing Standards Task Force. I do believe you have a book for sale here as well.
I do, yes, thank you.
Hessick attended Yale Law School, where she was the editor of the Yale Law Journal. After graduating from law school, she clerked for Judge Barbara S. Jones in the Southern District of New York and for Judge A. Raymond Randolph in the D.C. Circuit. She also worked as a litigation associate at Watchell, Lipton, Rawson, and Katz in New York City. Before joining the faculty at Carolina Law, Hessick taught at the faculties at Arizona State University's Sandra Day O'Connor College of Law and the University of Utah's S.J. Queenie College of Law. She also spent 2 years as a Clemenco Fellow at the Harvard Law School. Thank you so much for being here.
Thank you.
Christon Halkiotis is the managing attorney, owner, and CEO at the law office of Christon S. Halkiotis, PLLC, a boutique criminal defense firm here in Greensboro, North Carolina. She has been an attorney since 2004. Christon has previously practiced for 15 years in the Guilford County District Attorney's Office, where she was responsible for high-level felony prosecutions. She opened her own criminal defense practice in 2019 and now defends high-level felonies, capital murder, as well as other sorts of crimes and traffic offenses. She has tried high-level felony cases to juries as both a defense attorney and as a prosecutor. Christon holds a Bachelor of Arts degree in Political Science with departmental high honors from Rutgers University, as well as a Juris Doctor degree cum laude from the North Carolina Central University School of Law, where she was the articles editor of the North Carolina Central Review. We obviously have two incredibly distinguished women here tonight, and I will hand it over to you. Thank you so much.
Thank you.
Thank you. How are you doing this evening?
I'm really great. I'm excited to be here. Thanks for joining me.
Thank you. I appreciate the opportunity. Will you talk a little bit about why you wrote this book?
Sure. So the book is about plea bargaining. It's called Punishment Without Trial. And I wrote it sort of because I got sick of talking to my family at family reunions and having to tell them that they were wrong. So I'm the first person in my family to go to law school, and for most of them the only lawyer that they know. And when I became a law professor and started studying and writing about criminal law, they were, my family, I love them, quick to let me know what was the real deal with criminal law and criminal punishment in the United States. And I noticed when they would talk to me that they assumed people would get trials in front of a jury. And so they were less concerned about the decisions that prosecutors were making, the way that legislatures were writing the laws, and those sorts of things. And I kept having to tell them that things didn't work quite the way they thought that they did. And at some point I thought to myself, I mean, I love my family, but there are probably lots of other people out there who don't know this either. And given how much we rely on democracy in America to shape the criminal justice system, I thought it was especially important to write a book. The book isn't intended for lawyers, it's intended for everyone else to read about it and to understand the role that plea bargaining in particular plays, and specifically about how it's sort of the most visible piece of the criminal justice system that's designed to punish people without giving them a trial first. So that the book talks about a few other things, pretrial detention and bail, forfeiture, fines and fees, the various ways in which we sort of designed a system to punish people without giving them a trial. But plea bargaining is probably the biggest driver of that. And some of these other topics, I think, feed into it and touch on it as well. So basically, I wrote the book to win some arguments at Thanksgiving, I guess you could say.
And it's funny because you say that it's not a book aimed at lawyers, but when I was reading it, even after practicing law for 18 years, I found it so eye-opening, and it's something that I wish I had, that I wish the book had existed when I was a new prosecutor 18 years ago. I think it should be required reading for all new prosecutors, because it touches on some really important concepts that I guess we can kind of talk a little bit more about. But what kind of shocked you the most as you dove into the research for this book?
Oh, so, I mean, there were a lot of specific stories. So the book, I get it. It can be a little dry to just talk about law. You can ask my students, very boring sometimes to just talk about law. And I thought it would make more sense to illustrate these things through stories. So I initially was traveling around the country, interviewing people, visiting people. COVID hit, started doing all my interviews on Zoom. Luckily, some people who I think otherwise wouldn't have met with me, we were all sort of trapped in our houses. So like the district attorney of Boston was like, sure, I'll take that call. So some of the stories were especially shocking. But in terms of things that I learned, it's actually two things. One, doing the history of plea bargaining, because I mean, I went to law school in 1999, and everyone's like, yeah, plea bargaining. Everything's just plea bargaining. Plea bargaining is a big part of our system. It's been around for a while. What I didn't appreciate was exactly how modern it was. The Supreme Court didn't say that plea bargaining was okay until the 1970s. And actually, up through the end of the 1800s and through the beginning of the 1900s, when appeals courts, so not the trial courts, but the courts just above them, would find out about plea bargaining, they would get angry and they would say, this is corrupt, you can't do this. They would refuse to enforce the plea bargains. And so I was really surprised to learn how much pushback there had been historically about it, and then sort of that it only within the past century really, less than that, sort of like 70 years became popular, which I know sounds like a long time, but for law, 70 years is like the blink of an eye. They're like, oh, that's no big deal. Like we're talking about cases from the 1600s and stuff like that. But the other thing that I was really surprised by was some information that was gathered by a judge in West Virginia. I'm actually going to West Virginia next week to have a conversation like this with this judge. He was a Carter appointee, so he's been on the bench for a really long time. And he noticed in like the early 2000s that the federal prosecutor's office there kept going to the grand jury and asking them to return these indictments, right, these charges, like these 14, 15 count indictments where they would tell them all of the different crimes that they thought the defendant had committed. And then they would have the grand jury do all of this work, and then they would come into the courtroom and they'd have them plead guilty to one crime and they'd dismiss the rest. And he noticed that it was happening, and it was annoying him a little bit that the grand jury was doing this. And then one of the grand jurors ran into his wife in the supermarket and complained that it seemed like they had done all of this work, but the prosecutors didn't care. They were just going to have them plead guilty to one thing. And these were opioid cases. And as you know, some parts of the country have been hit really hard by the opioid epidemic, and that was one of them. And so the Judge Goodwin is his name. He thought that the government should have to explain what they're doing. Why are they doing this? Why are they asking the grand jury to do all of this work and then dismissing the rest of these charges? So we started asking the prosecutors, and the prosecutors, I think, were a little taken aback, and they'd say things like, "Oh, it's for resources. We can't bring these cases to trial." And Judge Goodwin's a little curmudgeonly, which a little bit of curmudgeonliness can be a good thing in a judge sometimes. And so he made his law clerks get all of the information from Washington, D.C. about federal trials. And he confronted the next federal prosecutor who said that in his courtroom, and he said, "You know what? I pulled the numbers, and in 1990, there were about 8,000 federal criminal trials in the country. Since 1990, we've added more judges, we've added more prosecutors, we've added more court personnel. And in 2016, I think this is when this was happening, he was like, we're down to 2,000 trials a year. So literally the number of trials is 1/4 was what it was 30 some odd years before. And yet, in that same time period, the percentage of cases that are being plea bargained has gone up. We're now at about 98% of cases in this country, 98% of convictions in this country are the result of guilty pleas, most of which are plea bargains, because you don't want to plead guilty unless the prosecutor's giving you something in return. So this led him to conclude that what was really happening here is we had just stopped caring about the right to a jury trial, or at least those people who were in a position to do something about it had stopped caring about the right to a jury trial. And so he wrote some opinions where he included these statistics, and I think that's really, really convincing to me, because everyone always says we need to have plea bargaining because we can't possibly bring all of these cases to trial, which, by the way, they're not wrong. We can't bring all of the cases that we have right now to trial. We have about 14 million criminal cases in this country every year. We don't have the resources to bring all of them to trial. We have the resources to bring a lot more of them to trial than we currently are. And for me, it's a real question why we don't, and whether we should. Spoiler alert, I think we should bring more to trial.
And I think it's hard sometimes too, defense attorneys are kind of caught in the crossfire a little bit because the prosecutors have all the power. And when I made the transition to private practice, one thing people would ask me is, what's been the biggest challenge that you've had to overcome from being a prosecutor to being a defense attorney? And by far, it is the power imbalance and getting used to that power imbalance, and honestly not even realizing just how much power there actually was being a prosecutor until I don't have it anymore. And now where I think I know what the right outcome of a case is for my client, the question is, I've got to go convince the prosecutor. I've got to go sell all the weaknesses of the state's case to the prosecutor, who has like hundreds of others and probably hasn't looked through mine yet, and try to pitch my client's case to say, hey, look, dismiss these charges or give us a misdemeanor, do something. So it can be incredibly challenging.
What happens when they don't listen? I'm sorry, I want to get her to tell some more stories, because as you can tell, I really like people's stories. So give me, if you can give an example. I know you have confidentiality concerns.
When they don't listen, it's incredibly frustrating, because then your client's between a rock and a hard place. And a lot of times, there have been cases that I would love to take to trial, and I'm ready to go. But the problem is, my client might have 3 prior low-level felonies, non-overlapping felony convictions, which makes him a habitual felon, which means the DA's indicted him as a habitual felon, which means that his punishment is going to exponentially increase if he goes to trial and gets convicted. And so, I've had cases I would love to try, but then, my clients are saying, I just, worry, because I'm going to go to prison for 25 years if they even convict me of 1 felony charge. And that's really, really frustrating, because it doesn't even go to the weight of the evidence in the underlying case. It's just this huge threat that's hanging out there. And I can never make a guarantee. I always tell people, look, if a trial lawyer ever guarantees you a result in a jury trial, they are sticking their hand in your pocket and just taking your money, because you can't guarantee. And there's always a risk with a jury trial. I've seen people get acquitted who should have been convicted. I've seen people get convicted who should have walked free. And it's kind of terrifying, actually.
Yeah, I want to give you guys a really concrete example of the sort of pressure that Christon's talking about, because it's a little it might not be super obvious. So I'll tell you guys a story. It's in the book. It's about a guy who was accused of fraud. And he thinks he didn't do it. He thinks it was just bad luck with his business. But he comes to the attention of some federal prosecutors, and they come in and they charge him and his business partners. And, you know, I know in this country we often talk about how people who commit white-collar crimes don't get punished enough. I think, you know, reasonable people can disagree with that. But I will say that federal prosecutors have some really harsh laws that they can use, right? In the wake of Enron and stuff like that, like Congress passed a lot of really, really, really harsh laws. So they brought these charges against this guy and his business partners, and they were facing a maximum sentence of 200 years in prison. They weren't going to get 200 years in prison, but we have these things in federal court called the sentencing guidelines. They were probably realistically looking at 25 years. And the prosecutor offers them, I don't know, 15. No, we're going to go to trial. We're going to go to trial. The deal keeps getting better from the prosecutor, and at some point the prosecutor offers less than 2 years. So this guy is in a quandary, right? Because what does he have to do? He has to figure out, this is gonna sound boring and math-like, but I promise it'll be easy. But he has to figure out his expected punishment. Do you guys have those friends who ever tell you, like, this is the time where it actually makes economic sense to buy a lottery ticket? You have those friends? And I'm always like, shut up.
I am that friend.
Are you? Yeah, but it's true. And somebody explained the math to me once, right? It's the odds and then how big the jackpot is and how much the ticket costs. And at some point, like, the cost of the ticket is less than the expected win, even though the expected win is like, you know, $5 and it costs $2 to buy the ticket, whatever. All right, your punishment is the same way, right? So imagine that you're facing 10 years in prison and you think that you have a 50% chance of getting acquitted. If the prosecutor is going to offer you less than 5 years, you should take that deal. You're hedging your bets, right? That's your expected punishment, 10 years, 50% chance of 10 years. Your expected punishment is 5 years. You should take it. So the guy who's facing this, they're offering him less than 2 years. He's probably gonna get 20 or 25 if he gets convicted. He has to say to himself, do I feel like there's a better than 90% chance that I'm gonna get acquitted? That's a really tough thing to estimate, especially because he probably doesn't have access to all of the information that the prosecutor does that would be introduced at trial. And that's another piece of this. And Christon, I don't know if you have any war stories you'd like to share, but one of the things about the power imbalance is not just that the prosecutor gets to decide whether to give you a deal or what kind of deal to give you, they get to decide what to tell you.
That's true. To an extent, I will say, and I know there's a story in the book that talks about a prosecutor, a gentleman who gets arrested for some B&Es, and then there's a rape that occurs, a burglary and a rape. And will you tell that story?
Yeah,
and then I can piggyback off that.
This is a man named Joseph Buffy, and he broke into at night to steal things, which is not a good profession to have. But one night he got caught breaking into a commercial building, and police accused him of a few days before having broken into an elderly woman's house and raped her. And he was like, no, I definitely didn't do that. I mean, I broke into this place, and here's some other places that I broke into, but I didn't break into that place. And he kept insisting he didn't do it. And his lawyer said, well, how about you do a DNA test? And the prosecutors are like, look, we've got his DNA. We're happy to do the DNA test, but you know, DNA tests are often inconclusive. So if you make us do the DNA test, we will. But if it doesn't exonerate your guy, then we're gonna insist on the maximum and we won't offer you any deal at all. And although there are problems prosecuting sexual assault cases in this country, like the punishments on the books are incredibly, incredibly harsh. Like they're not murder harsh, but they're like a fraction of a step below that. So Joseph Buffy had to decide what to do, and his lawyer convinced him to take the deal, where he pled guilty, and I forget how many years he got sentenced to in prison. But at some point he got really angry, and he's like, you know what? He's like, I think my lawyer steered me wrong. We should have waited for those DNA tests. He got a new lawyer. the new lawyer starts doing the work on his appeal and finds out that the prosecutor already had the DNA results and they proved that it wasn't him.
And in that situation, apparently, I think then he ended up being released from prison because
Eventually.
the DA had lied, had straight up lied and said, we don't have this. And they actually did. But there are plenty of times, and obviously that's not okay because the prosecutor's not allowed to lie. But what they are allowed to do is they are allowed to make offers with, if that DNA hadn't come back yet, they can still make the offer and just say, hey, look, the DNA is out. Your guy can plead now and he gets this. But if the DNA comes back and it's him, that offer is revoked. And that happens all the time, and it doesn't just happen with respect to things like DNA. An example that I get frequently from prosecutors that are my opposing counsel is the issue of body-worn camera footage. A lot of times I'll get the initial discovery and I won't yet have a link to the body-worn camera footage from the police department. It hasn't been uploaded or the DA's office doesn't have it yet in the system. And the DAs, when I say to them, hey, I think there's some body-worn camera outstanding, may I have that so I can review it with my client? They'll say, that's fine, I'll get it for you, but I'm treating it as trial prep, and if you make me do that, I'm revoking the offer I gave you, and then if it's worse for your client, you're gonna get a worse offer, or there's not gonna be an offer. So that does happen. And unfortunately, that's okay. Okay. Per the Supreme Court, it's okay.
And I'll just add, the West Virginia Supreme Court said Mr. Buffy's rights were violated. The US Supreme Court has never said that prosecutors can't lie like that. And there's a case right now out of Texas of a guy who also got lied to. It wasn't DNA evidence, but a victim had recanted and the prosecutor lied to him and he pleaded guilty. And so he's asking the US Supreme Court to take his case and to agree, A, that you can't lie, and B, that if you have that sort of exculpatory evidence and you're the prosecutor, that you have to turn it over. Because up until now, the US Supreme Court has not said that prosecutors have to do anything during plea bargaining.
And I will say that under our rules here in North Carolina, under our rules of professional responsibility and the special duties of a prosecutor, there are rules that say things, for example, like a prosecutor can't proceed if they know that their case is not supported by probable cause anymore. And I think there's some other rules that can kind of be applied to that situation. But certainly that's just not a good look for anybody. And I will say too, I did bring with me, if anybody's interested in picking up a copy afterwards, I have some copies of the North Carolina Rules of Professional Responsibility for Prosecutors, as well as actual copies of plea transcripts and what they look like here in North Carolina to give a little bit of context to our discussion. If you're interested in picking up a copy afterwards, I'm happy for you to take them.
Best moderator ever.
And these are transcripts of pleas that are used. We're talking about pleas to felony cases or to misdemeanors that have been appealed from district court to superior court. So we're talking about proceedings in superior court, which is where our felonies are disposed of, and of course misdemeanor appeals from district. In district court in North Carolina, where misdemeanors are disposed of, the Constitution basically just doesn't apply there. It only applies, your rights only apply in superior court. That's where the court reporter is. There's no court reporter in district court. You have the right of appeal for a trial de novo or a new trial in superior court, and that's where your rights attach.
Crazy. So crazy. Not the sort of stuff we teach our students in the classroom. We're like, and then you get a jury, and then blah, 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 blah. Yeah.
Because we did talk a little bit about the kind of pretrial plea bargain phase where they don't have to hand over this stuff or discovery, anything else that they've got. Would you talk a little bit, because I do find it extremely fascinating, and I know we spoke about it a little bit yesterday, the amicus brief that you were a part of.
Oh, yeah. So the case that I told you about, the case out of Texas, where they're trying to get the Supreme Court to say it shouldn't be the wild, wild west anymore at plea bargaining. Like if our country is going to rely on plea bargaining for 98% of its convictions, then maybe we should take a look at the process associated with plea bargaining and, I don't know, have a process. I'll tell you, if any of you have ever been involved in a civil lawsuit, it looks really different. Civil lawsuits also settle most of the time, but there are a lot of procedures associated with it that give both sides a lot of information. The judge has an opportunity at which he or she is supposed to look at the legal arguments to decide whether the person who's suing actually has like the right legal arguments. Then they have to turn over all sorts of documents. They have to have these interviews called depositions, and then the judge has another chance to decide whether there are facts to support the person's case, and if there aren't, they kick it out. So there's all of this procedure in civil court. There's very little procedure in criminal cases if you plea bargain. If you go to trial, there's tons of procedure, but most people don't go to trial. So a few years ago, about 10 years ago now, the Supreme Court said, if you have a lawyer who's no good, who's so bad that that the lawyer's representation of you falls below what the Constitution requires, then we're going to let you like withdraw your plea, and we'll say that your rights were violated, even though what you did was plead guilty, or you didn't plead guilty because your lawyer gave you bad advice. We'll say it actually violated your rights to go to trial. It was a big deal that the Supreme Court said these things. So basically, this case out of Texas, there are a bunch of us who are trying to encourage the US Supreme Court to take it and say, look, it looks like you had a little bit of interest in making sure that the Constitution isn't a total dead letter in plea bargaining, and here's where you should step in. And we say the things like the story about how to calculate your expected punishment. And one other thing, I helped write a brief for myself and a bunch of other law professors. We say the US Supreme Court, when they said that plea bargaining was constitutional, they had to overcome is sort of maybe too generous of a word. They had to deal with the fact that they had some cases from before that suggest it wasn't constitutional. So they have a series of cases that basically say the government can't punish you for exercising your rights. So for example, if you are collecting Social Security, the government can't say, we're giving you this benefit, and in return, you have to promise, never to go to a protest or something like that. They can't say, we're gonna put an unconstitutional condition on the benefit you're receiving. So you've got that line of cases, which it certainly sounds like an unconstitutional condition to say, the benefit of the plea bargaining, the benefit of less time in jail or the benefit of fewer charges is conditioned on you waiving your right to a jury trial. So there's sort of that line of cases. There's another line of cases, which was like, actually a major piece of them comes out of a case from North Carolina where somebody had been convicted at trial and there was an error at the trial, and he appealed, he got it reversed, the judge was told that he had made an error, sent it back for a new trial. Guy still got convicted because apparently he was guilty, but after the conviction, the judge imposed a harsher sentence. And it seemed pretty clear that the judge imposed the harsher sentence because the judge was annoyed that this guy appealed. And the US Supreme Court said you can't do that. You can't retaliate against someone for exercising their constitutional rights. So here we are in plea bargaining, and there's a case, it's a case out of Kentucky, this is back a while ago now, and the prosecutor said, if you don't plead guilty, I'm gonna bring this new charge, so instead of spending 5 years in prison, you'll spend life in prison, it'll be a life sentence, I'm gonna add this extra charge. And the guy was like, I'm not gonna plead guilty, and then he gets convicted because he was guilty, and he gets sentenced to life because the prosecutor added it. And he appeals, he's like, whoa, Supreme Court, you've got that case from North Carolina, don't retaliate. And the Supreme Court says, it's true, we do have that case. But we've also said plea bargaining is constitutional, and the whole idea of plea bargaining is to have a give and take. And if we said that the prosecutor can't retaliate, we basically have to blow up plea bargaining because the prosecutor has to have leverage in a negotiation. So we aren't going to apply those cases, and we're going to say that this is okay because it's not simple retaliation like what the judge did. It's part of a negotiation. It's part of a give and take. So our brief, to make a very long story slightly longer, is to say, if plea bargaining is going to be consistent with all of the other constitutional law that you have, then you have to take steps to make sure that there is a give and take, that there are negotiations that look like negotiations and don't look like just somebody being pressured into doing something.